Important thing is to recognise the difference between estate assets and non-estate assets.
Yeah, and that's part of the planning process. In order to really know what the will's going to look like or what your estate plan's going to achieve, you need to know what you can deal with directly through your will and what you can't.
Yes.
Now, it's a distinction between estate assets and non-estate assets. Now, many people, when they sit down to draft their will, think that everything they own and control can be dealt with via their will. And they're shocked to realise that that's not the case.
So what are some of the assets that do fall under the will and some that don't? So the family home?
Family home, that's a really good example. So if I own my family home with my spouse, and I own it jointly, and I die first, that's a non-estate asset. It's going to pass to my wife by survivorship automatically.
Because it's held jointly?
Because it's held jointly.
Yes.
So a lot of people come in and say, I want to give my half of the family home to X. And you say, well, actually, you own that jointly with your partner. You can't do that if you die first.
Yes.
So looking at the title of your property, just working out a simple thing like, how do I own this piece of real estate? Do I own it jointly with somebody else?
Yes.
Do I own it in my own name? Or do I own it together with somebody else where we both have a distinct interest in that asset that I can deal with via the will?
Yes.
So these are some of the things that you need to start thinking about. Sounds more complicated than it is. It's just a question of doing a title search and realising what's on the title. So don't be put off by that. But
so what you were referring to there is that you can own things jointly.
Yep.
And you can own them as jointly, tenants in common.
Tenants in common, which means each owner has a distinct interest that they can deal with under the will.
So it might be 50-50 or 60-40.
Yeah, that's right.
Yeah.
That's right.
So that in that case, if it's tenants in common, it wouldn't be an estate asset.
If it's tenants in common, my interest in it would be.
Yes.
If it's owned jointly and I die first, my interest is not an estate asset. It goes automatically to the other owner.
Okay.
Any other assets owned in my name personally that are not owned jointly with another would form part of my estate. So motor vehicle, bank account in my name, shares that I hold in my name, chattels, the plates, the clock, the piano, those kinds of things, they're mine, I can deal with them.
Yes.
What else?
So I guess the other things that potentially you don't own outright by yourself or don't fall under the will, we'll get to it more later, is superannuation and trusts and all those other investment vehicles that are becoming more and more common.
Correct. And some people do think they own the assets that are held in a trust, for example. When you explain that you control the structure, you don't own the asset, that can come as a bit of a shock. So at the planning stage, it really is just it's an audit process. It's a data collection process. What do I own? What do I control? What can I deal with in my will? What can't I deal with in my will?
Yes.
And that's where that collaborative process, talking with the financial planner or the accountant, is really helpful, because they can dissect all of that and say, well, you own the family home personally, but your beach house is in a family trust.
Yes.
Or you can't give away your super because you've done a nomination to somebody else.
Exactly.
So, yeah, that's the importance of collaboration.
Okay. So that's estate assets. Non-estate assets, we've talked a little bit about as well.
Yeah, and look, some of them can be made into estate assets by nominations and whatnot. We can talk about that later. But again, it really is important to understand what you control but cannot give away directly. Because look, an example that might assist is a will that I saw a number of years ago, where the will maker had made his own will and he'd given away a life insurance policy. Problem was, he didn't own that life insurance policy, and so that created a funding problem within the estate, because he directed that life insurance policy be used for a specific purpose in the will. It had a nominated beneficiary, so he couldn't give that away.
Yes.
So the funding of some of your estate planning objectives can be thwarted by not fully understanding what you can actually give away.
Yes.
So you've got to be very, very careful.
So particularly for non-estate assets, but the key thing is knowing what you own and how it's owned, and so that then you can execute or have a will set up so that your intentions can be implemented as you intended.
That's right. Yeah, that's right. There's no point creating a terrific estate plan that's going to fall in a heap when it's actually implemented later on.
Exactly.